Hello again. I'm Dr. Chris Rapoff of EZ QME Continuing Education, and welcome again to this week's Case Law Update. In the Matthews versus Sutter Health System office, the defendant sought a reconsideration of a workers' compensation judge's conclusion that the judge actually erred in his application of Labor Code Section 5412 as it related to the applicant's CT injury. Very interesting. So who was right? Well, let's find out. So in this case, the defendant is contending in their petition that the workers' compensation judge should have made a finding of a date of injury for this applicant pursuant to Labor Code 5412 or Section 5412. However, the defendant did not raise this issue at the time of the initial trial, but later. And then they specified that the applicant was employed by the employer, obviously, during the cumulative trauma period up to a date of August 5th of 2021. This comes into play in a bit. The Workers' Compensation Appeals Board questioned whether the defendant had actually conflated the definition of a cumulative trauma period, which is a period of injurious exposure, and also the definition of the date of injury under Section 5412. I realize that this may already sound a little bit confusing, so let's review Labor Code Section 5412. It defines the date of an injury for an occupational disease or cumulative trauma injury, so we're discussing a date. Specifically, the California Labor Code Section 5412 states, quote, "The date of injury in cases of occupational diseases or cumulative trauma injuries is that date upon which the employee first suffered disability therefrom and either knew or in the exercise of reasonable diligence should have known that such disability was caused by his present or prior employment." That is the actual definition. So let's affirm some of the findings of fact here. The petition, or the defendant here, alleges that the court actually erred in finding a CT injury on 8/5/2021 and not analyzing the date of the injury under Labor Code Section 5412. The applicant alleges the injury to her left upper extremity, which included the left shoulder, the left elbow, left wrist, and left thumb, during a CT injury date ending on that date of August 5, 2021. The defendant denied the injury. The sole issues presented to the court in this case were that the injury arose out of and in the course of employment, here's your AOE COE, and in the need for further medical treatment, which is the definition of an injury. The parties utilized a QME to resolve their issues. Additional facts of the case will help us understand a little more. And the QME examined the applicant and they provided a report in the end of 2021, approximately 4 months after the claim of the injury. The applicant gave a history of pain in the left upper extremity, the elbow, hand, and wrist, and the pain began around 2007. She underwent surgery, and several actually, carpal tunnel surgery in July of 2013 and March of 2015. In addition, they did an ulnar nerve decompression in 2015, followed by another surgery in 2016. So in 2019, the applicant experiences pain additionally in a workload that as well as an increase of her symptoms. So the applicant's employment also did end in 2021. So from 2013 to 2016, she underwent 4 surgeries, and then in 2019, she began to experience additional pain and finally left the job in 2021. So in his reporting, we find that the QME diagnosed an injury to the applicant's left elbow, wrist, and left thumb, and opined that they were due indeed to a CT injury ending in the date of August of 2021. And he also found that the applicant at that time was not PNS yet, or permanent and stationary. So the defendant then deposed the QME in 2022 And the QME testified that a CT trauma was the injury, and it, quote, arises out of a longitudinal history of repetitive exposures that, if isolated, would not cause a particular diagnosis, but when amassed over a period of time will lead to a gradual development of an injury, impairment, and disability. This is exactly the definition of repetitive injury or CT injury. So the QME went on to say that he continued to find that the 10-year history of repetitive administrative duties while working, get this, as a claims adjuster for Sutter Health, pretty ironic, did contribute to the causation of her left cubital tunnel and left carpal tunnel diagnosis. The QME also testified that he would preliminarily find 4 separate CT injuries, each ending on the date that the applicant had her surgeries. Very interesting. He's separating these out specifically. The QME testified that the only changes to his report was that he discussed the relevance of these multiple apportionable factors of CT trauma exposure, and this would apply to apportionment of permanent disability. He further confirmed that the applicant's work activities through the last date of injury of August of 2021 played a causative or contributory role to the applicant's left upper extremity issues. Therefore, the AOE-COE issue is not a question. This is where it gets a little hairy. The defendant argued in court that the court had actually erred because it did not apply the correct legal definition of cumulative trauma injury. Specifically, the defendant argues that Labor Code Section 5412 is the correct legal definition to utilize to determine causation of a cumulative trauma injury. Well, the Workers' Compensation Appeals Board had something to say, and they stated that that was, quote, an incorrect legal theory. And they went on to tell us that a cumulative trauma is defined under Labor Code Section 3208.1 as, quote, a repetitive mentally or physically traumatic activities extending over a period of time and the combined effects which causes any disability or need for medical treatment. This is Labor Code 3208.1. They went on to say that the combined effects of the applicant's job duties played a causative or contributory role in her left upper extremity issues, according to and agreeing with the QME's testimony. And according to the petition for the reconsideration, an analysis under Labor Code 5412, Section 5412, is critical to the definition of a CT trauma, which we know. So Labor Code Section 5412 determined the date of a cumulative trauma, not the definition of a CT injury. So let's keep in mind that the date of an injury under a CT trauma has many legal ramifications, such as the compensation rate, the statute of limitations, and the dependency status, but it does not affect if the applicant's injury arose out of and during the course of her employment in this case. Okay, the Workers' Compensation Appeals Board was not done with this defendant. They went on to say that obviously the Labor Code Section 5412 requires the concurrence of knowledge and disability to determine the date of the CT. The defendant argues that there was no disability at all due to the 8/5/2021 CT claim. So they even went further and said, that to argue that the applicant did not have any disability at the time of her employment ceased in 8/5/2021 is absolutely nonsensical. The QME testified that the work after the applicant's numerous surgeries contributed to her left upper extremity issues. So even under the defendant's incorrect legal analysis, there would be a viable CT trauma injury. Now, hence the defendant's statement of the alleged injury of August 2021 did not cause a need for treatment or disability was absolutely factually incorrect, according to the Workers' Compensation Appeals Board judge. And the question arose as to whether or not there were the numerous CT dates as determined by the QME. If you recall, it was based on the 4 surgeries that this lady had undergone due to the injuries that she sustained, and the court did not find that there were or were not multiple CT traumas, as there was no application for multiple CT traumas provided, and the court lacked the jurisdiction to make such findings. So that was interesting. They actually backed off of that. So instead, the court focused on the CT trauma that was pled. So based on the fact that the QME both reported and testified that the applicant's work duties through her last day worked, there was no medical evidence to the contrary. So the Workers' Compensation Appeals Board concluded that there was no further analysis necessary in this case. So here we have another very interesting case, and in this instance, the defendant misunderstood a really basic principle when it comes to defining CT injuries in the California Workers' Compensation system. The Workers' Compensation Appeal Board's ruling set them straight pretty much in this case and sided with the QME and the initial workers' compensation judge by affirming that the original findings of fact and denying any reconsideration of the initial ruling. So once again, this illustrates how important it is for us as a QME to know your stuff. Apply it when providing the parties with a top-notch QME report. So once again, doctors, I hope you enjoyed this presentation, and it seems to validate the good work that we still continue to do as QMEs and strive to do. And we want to provide the most accurate and the best QME reports in the industry. So I'm Dr. Chris Rapoff, and I wanted to thank you again for taking this time to join me in this presentation. I hope you've enjoyed it, and I look forward to sharing another one with you very soon on another interesting case. Until then, take care.